Hello everyone, myself Madhuri, Associate Professor, Department of Law, Padmavati University. We'll have another session in a company law, that is a majority rules, reconstruction and amalgamation. Majority rule is a fundamental principle in a company law that also played a significant role in a corporate decision making and governance. And some points we can remember, that is, majority rule in a company law states decisions made by the majority shareholders either through voting or a general meeting or by written resolution and the binding principles of the particular company. The decisions of the particular majority prevails over those also will be taken under minority. Voting power, types of decisions and the quorum will be taken into consideration. Shareholder is directly proportionate to the number of shares they hold. And coming to this majority rules applying various types of decisions including election of a particular directors, approval of a financial statements, amendments to the particular company's articles of an association and authorization of a significant corporate actions. And quorum, you have to take a valid decision meeting, typically required quorum, which is the minimum number of participants of a shares or a shares represented. The quorum is often defined the company's articles association by the laws. Majority there also will be taken under the decision to be binding, and ordinary resolution may require a simple majority more than 50%, with special resolutions may require high majorities. Protection of minorities also should be taken fundamental, and at the same time company laws often provisions to protect rights and interests in the minority shareholders. For example, some jurisdictions may allow minority shareholders challenges decisions they believe in an offensive and unfair prejudicial manner. Abuse of a particular majority also comes under the decision making, and it does not give majority shareholders unlimited powers. There are also limits in what a majority can be taken or what kind of decisions. Proxy votings also will be taken into the particular ways on behalf of any kind of meeting, and it also allows broader range of particular shareholders to participate in a decision making. Written resolutions also should be taken according to that, and at the same time the majority rules still applies to the written resolutions with decisions based on majority support. Exceptions also we can consider under the particular special provisions which is to be taken under majority rule. Amending a particular company's memorandum and articles of association or undertaking actions that signify effect of a particular company's structures. So rules, we can say it is very important, fast versus whole bottle, and there is an action also which has been taken against this one. So a derivative action is a legal action brought by the shareholders on behalf of the companies to assert for a right or a claim against the third party such as company directors or officers. For actions that harms in the company, it is not personal action by the shareholders but rather than action in a representative capacity. And the action must be in a company name, and the shareholder should act as a good faith according to the particular behalf of a particular company best assets, and the rules has been taken according to this. Exceptions we can say is a fraud on the minority, and such cases the shareholder may bring a legal action directly even without company's involvement. Preventions of a particular multiple suit also should be taken according to their multiple redundant lawsuits also should be taken. So modern company law also stands on this shareholder, especially in the case involving the corporate governance issues and shareholders. Court's discretion also will be taking on that one. Reasons also should be taken. Amalgamation and reconstruction, if you want to see, there should be a merger involving a combination of two or more companies to form a new entity, or the absorption of one company and another. It is a legal and financial reconstruction of a particular process. Amalgamation and reconstruction are the two important concepts of a particular company law, reorganization or the combination of the companies. This always gives you a legal, financial and operational implications which is to be understood by the company law. Amalgamation and the nature of merger will be coming under the particular way of a new entity, the assets and liabilities of emerging companies. Amalgamation in the nature and purchase also should be taken. Approval also should be necessarily required for the legal requirements. Transfer of assets and liabilities also should becomes according to one or more companies to another. Protection of the stakeholders will be taken according to that legal provisions. Tax implications and benefits also should be taken. A reconstruction, if you want to go financial and the structural reconstruction of the particular company, changes the company capital structure, objectives and the management. A reconstruction purpose is nothing but understanding and undertaking for various reasons, including resolving financial difficulties, changing the company's directors, or strategies complying with the regular requirements. Capital reduction and redemption also should be taken. So creditor and the shareholder approval should be there. Protection of a minority shareholders and valuation and accountancy also should be there. So reconstruction stands, it involves the values of assets, liabilities and the shares. Accounting methods, disclosure requirements are essential in the components of the process. Disclosure and the complaints also will be taken under the transparency, and regulatory requirements are the critical reconstruction to ensure that all kind of stakeholders are informed and treated fairly. Finally, I can say as a result, essence here is that will and the decision of the particular majority shareholders would succeed, which shall consequently result into the binding of a particular members of a particular minority shareholders, and this is known as the rule of majority. It can cover all kind of lawful arrangements that touches the considerations and concern the rights and obligation of the company and its shareholders or the creditors. Section 494 of particular Companies Act 1956, which similar to the section 287 of the Companies Act 1948, gives power a company to reconstruct and amalgamate by means of voluntary liquidation. Thank you.